LeMan sits on death row today based on the testimony of a lying witness and jailhouse informants who later recanted. Here to tell us about her story is Nichole Manna, investigative reporter at the Tributary. Welcome, Nicole.
Hi, thank you for having me.
This is an extraordinary three-part story that just landed this week, and I know you've been working on it for a very long time. But start us off, if you can, about kind of bring us up to speed on Kenneth Hartley. He's on death row. He was accused in a 1991 murder case, and a case that the prosecutor at that time even called weak when he first
Correct.
got it.
Correct. In reporting this story, it's all from public record requests that I got. And in one of those public record requests is the prosecutor's notes that says must talk to victim's family about weak case. Kenneth Hartley has been on death row since 1993. He was accused of killing 17-year-old Gino Mayhew. And as the prosecutor said at the trial, it was an unsolved mystery, or I'm sorry, an unsolved murder until this man named Sidney Jones called police and came forward and said, "This is what I witnessed. I witnessed the kidnapping. It was the kidnapping that happened before the murder." And so the case kind of went off from that, and they made arrests of Kenneth Hartley and his two co-defendants. At the end of the trial, Kenneth Hartley and Ronnie Farrell ended up on death row. Sylvester Johnson was given life in prison. Ronnie Farrell is now in prison for life. His death sentence was remanded because he was able to successfully argue ineffective defense counsel.
And so Kenneth Hartley, one of these three, remains on death row. His chief witness against him, Sidney Jones, was a really problematic witness for a number of reasons. Can you explain, first of all, who Sidney Jones was, how he got involved in the case?
Yes. So from what we have gathered from the court documents, he called police at some point from jail and said, "This is what I had witnessed." The prosecutor in the trial said Sidney Jones came forward out of the kindness of his heart. We have learned that Sidney Jones actually thought he was going to get paid for his testimony, which kind of reveals his background. He was a paid confidential informant for JSO. I have documents of payment vouchers going back to about 2 years before the murder. I've talked to a local attorney who had documents going back to 1970 who said Sidney Jones was financially backed by the Jacksonville Sheriff's Office. On top of that, Sidney Jones was a witness in a 1979 murder case, completely separate from this, on the stand, went to trial, gave testimony, and then almost immediately recanted that testimony after he left the stand and said, "I lied, I made that up." And he was convicted of perjury. He got 3 years in prison. 10 years later, that goes to the Florida Supreme Court. They overturned that perjury conviction on a technicality, saying that the judge erred in not bringing Sidney Jones back to the witness stand. But that doesn't mean that Sidney Jones didn't lie. So he was still a liar after that decision. None of this was disclosed by prosecutor George Batay to the defense or the jury.
So basically, the prosecutor in this case used someone who'd been prosecuted and convicted of perjury as his chief witness in this case and didn't tell the defense.
Exactly. And Sidney Jones was the only witness to this alleged kidnapping that happened. The second witness had alleged that he just passed by Gino Mayhew's vehicle, saw Ronnie Farrell in it, and another man.
And so Sidney Jones, in addition to being a known perjurer, um, he had actually become such a problem for his handlers at JSO that they stopped trusting his testimony. And in fact, you found a payment voucher from JSO to him as a confidential informant and scrawled across it in huge black letters. It just says blackballed.
Yes, so that word is on the payment voucher and his what looks to be almost an application to become a confidential informant. We don't know when that was written. It just on the dates appears that it could have been before the trial. The last payment voucher that I have been able to find from him was a few days before the murder took place. But we were never able to connect exactly when he was blackballed. We're also kind of unable to connect exactly what that means. And I found in this slew of requests that I made an email that a former JSO detective sent to an attorney in 2008 that says Sidney Jones is lying. POS, and we still nobody will admit to why he was blackballed to this day.
Yeah, and so that was somebody that had worked with him, this detective that called him a lying.
Yes,
Yeah.
yeah.
Um, so, this is part of his record as somebody who was not reliable previously, but we know from your reporting that he also lied at trial, that he testified to the jury that he was a six-time felon. He was actually a nine-time felon with four misdemeanors. How significant? I mean, there's a pretty high bar, as you say, for having any impact on a death case. Generally, higher courts don't like to reverse a jury verdict. Um,
Yes,
s-
yeah. And I've talked to a couple of attorneys who do this, pro bono, who look at death penalty cases and bring them forth for appeal here and in other states. And they say, in where Kenneth Hartley is in the process right now, his attorneys have to prove that this information could not have been available to him before and was not available to him before. It's called right for review. So they have to make sure that their argument in the appeal is new, and hasn't been argued before. So the argument really hinges on this Sidney Jones and his background, how that was never disclosed to the jury, and these three informants that you mentioned earlier. Um, of the three informants, two have died since, but two of them, one before he died, recanted their testimonies in various ways and said we made up our testimony. And one went as far as to say, I was given the information that I needed to testify to. That was backed up by signed sworn affidavits from other inmates who were in the Duval County Jail with these men, from 91 to 93. And I was able to actually talk with one of them myself, who also confirmed that the jail was this hive of informants in the 90s, and everybody was looking to jump on a case.
yeah, and I want to get more to that in just a moment about why people would be volunteering themselves to, serve as a witness in a case. But first, I just want to ask you about this disclosure. You report that the prosecutor, George Batay, he was asked by the attorney, the defense attorney in this case, Hartley's attorney, whether any of the witnesses in this case had a history of perjury. And you report that the prosecutor said he didn't know and the attorney should just try to find out for himself.
Yes. So these documents are very common in murder trials, and I'm assuming most other trials, where the defense attorney will ask, like, "I want to know your witness's criminal history." They ask the perjury question, and then the response. This is all through documents, and the response from George Batay was unknown to us, but you can look for yourself. And it's interesting because I have talked to prosecutors who said of that time, it's not impossible for a defense attorney to find history of witnesses, but it's really hard. And then I have talked to defense attorneys who said it's almost impossible in the 90s. We can't just go on Google and Google search Sidney Jones. And so it would have been completely unknown to them if that was not disclosed. So that's part of the argument that's ongoing now, is whether or not this prosecutor broke what's called Brady violations by not disclosing favorable evidence to the defense team.
And it was that prosecutor's office who had
Yes.
prosecuted the perjury case. So it
Yes.
would not have been unknown.
Right. I mean, and that's a major question I've had is, how, if he didn't know, how is that the case? Because, not only was it his office, he was a prosecutor in that office at the time. He wasn't on the perjury case, but he was in that office, and they fought that all the way to the Supreme Court.
So you spoke to George Batay in your reporting on this. You spoke to basically everybody that was still alive and willing to talk. And he didn't necessarily comment on your findings, but you did present your findings to him.
Correct. Part of my process was I wanted to make sure that there were no surprises in this story. So anybody who's mentioned in the story who is still alive, for instance, Detective William Belina died in 2017, so can't talk to him. So everybody else, I tried to be really diligent in making sure they knew exactly what was going to be in this story. Mr. Batay declined to answer my questions and to comment on any of that, but he had the findings before publication, and he offered the comment that is in the story that is just kind of an overall about his career as a prosecutor and how he always, tried to be fair and felt that he was fair and honest.
So let's talk about his career as a prosecutor, because that's sort of the second part of this three-part investigation. He worked at the prosecutor's office for more than 30 years. He retired in 2008, and he had a reputation of being a very aggressive prosecutor. Some people thought that he crossed the line on some occasions, and in fact, he had a couple of cases remanded by the Florida Supreme Court because of prosecutorial misconduct.
Yes. So two of those cases happened after the Kenneth Hartley conviction. And in both of them, he had been admonished for certain statements he made during closing arguments, statements that the Florida Supreme Court said dehumanized the defendant. And those, remand, like, that led, sorry, to, it's so complicated. That led to the Florida bar, a different entity, to then open up an investigation of their own into those cases. And they were the ones that said, we're not going to reprimand you here. There's not a case for reprimand for us to do that. But, please don't cross or go to the line again, was kind of essentially the letter that they sent him.
It was interesting too, he was represented in that case by an attorney of his own,
Yes.
and that attorney's argument as to whether these statements were appropriate or inappropriate that dehumanized the defendants, his response was, "He's done this in 20 cases.
Yes.
This is not isolated. This is not a unique event, and you've never complained about it before."
Yeah, I thought that that was really interesting to admit, like, oh yeah, these things that you're admonishing for him now, he's done before, like 10 to 20 other times. And in those cases, if you could go back to the Supreme Court website and read through all of them, there are actually objections made by the defense counsel in that case. So it does make me wonder how those other cases, went by. Were there objections to what he was saying? Kenneth Hartley, I believe, at some point used both of those cases as an argument in an appeal, but the Supreme Court did not agree with Kenneth Hartley's arguments in that case. And at that point, I believe the makeup of the Supreme Court, the Florida Supreme Court, was also different.
Sure. And you spoke to a number of people, on and off the record for this story. We should say that you spoke to some people that defended George Patay and his conduct and his performance at the state attorney's office vehemently. You talked to former mayor and former prosecutor John Delaney, who said, who defended him and said that, he was a very ethical and very, reliable person. And he sort of said that, if people are saying something nice about a prosecutor, defense, that they're always going to criticize a prosecutor. If they say anything nice about a prosecutor, it's because the prosecutor's soft.
Yeah, that seems fair, and
Yeah.
kind of what I gathered from this. And if a prosecutor is talking really good about a defense attorney, it seems like maybe that defense attorney is also soft. So it was interesting to see that going both ways.
Yeah. The reliance on jailhouse informants, however, was a hallmark of this particular prosecutor. You found that there were people who said that he used jailhouse snitches in virtually every major case that he had. These are people that worked with him. One gentleman who's known him since childhood, essentially, and said that even, though he worked side by side with him as a prosecutor, that he'd used, a confidential informant or a jailhouse snitch in one case, and he thought that George Batay used them to almost an extreme.
Yes, I've talked to so many people who have said, "Oh, every single case that he was on, he was using informants." And Mr. Pate was the type of prosecutor that was taking on the hardest cases and the worst crimes. So that you have to imagine that that means every single one of his homicide cases used an element of informants. And one attorney I talked to, Rick Sikta, actually said that one of the informants in the Hartley case had been used as an informant by the state attorney's office in two other cases. One of those cases was prosecuted by George Batay. So it's interesting that this almost like cycle of informants continues to be used.
And we know that that was a different era. You talked to people back at that time saying, inmates had full access to the TV, to the newspapers. They were very familiar with the contents and the findings in a criminal case, and were therefore in a unique position to offer up case information that would appear to be, informed, reliable. Why was there such a reliance at that period on confidential informants, jailhouse snitches, and has that changed?
I think with Kenneth Hartley's case, the issue is that there were no witnesses. There was just this liar, Sidney Jones. There was one other man who had some sort of testimony that multiple people have now said scientifically couldn't be correct. He couldn't have actually seen what he said he saw. So when you have nothing else to go on, jailhouse informants are the next best place because they're they're with your defendant, and the allegation is that they talk to each other, and it's pretty easy to bring an informant who's already in custody onto a witness stand. And it's easy because they knew, and this was said by the informant, or not the informant, the inmate that I had talked to, and then all of the other inmates who signed affidavits, that they knew that they could get a deal. In fact, one of them said that everybody in the jail knew the state attorney's office was always open for business back then.
A lot in this story, too, about the rewards that people got for this kind of testimony. Nichole Manna, her story is available at jaxtrib.org, a three-part series, extraordinary reporting. Thank
Thank
you for
you.
being here.
Yeah, thank you.